A legal analyst has reacted to Gina Carano's lawsuit against the Walt Disney Company and Lucasfilm, describing it as a slam dunk case for Carano. Before we get into this, I'd like to ask you, please hit that subscribe button, hit that bell for notifications so you don't miss any of our future videos here at the Trent Report. With that out of the way, let's get into this here. Legal analyst Andrew Esquire, who runs the Legal Mindset YouTube channel, shared his expert opinion on Carano's lawsuit against the Walt Disney Company and Lucasfilm. He did an entire live stream going over the entire lawsuit. And when he was reading about the section on wrongful termination, that's the main complaint that Carano has filed. There's like 3 different complaints. There's wrongful termination. There's wrongful termination and like preventing her from being hired elsewhere. I think that's not the exact phrase. I don't remember what the exact phrase is. And then there is sex discrimination. So he goes over this California statute that they are suing for wrongful termination. And it says no employer shall make, adopt, or enforce any rule, regulation, or policy forbidding or preventing employees from engaging or participating in politics or from becoming candidates for public office, controlling or directing or tending to control or direct the political activities or affiliations of employees. And then this was his analysis. He said, political speech is a political activity. They terminated her based on her posts, which were political in nature, which was trying to forbid her from engaging in politics, therefore controlling her. So he's saying that what they did to her obviously falls into this California law, and she has right to sue and has massive cause. He then cited another portion of the law that says it goes on to say no employer shall coerce, influence, or by any means threaten of discharge or loss of employment to adopt, follow, or restrain from adopting any particular course or line of political action or activity. He said they're dead to rights on this. They're dead to rights on this. This fits neatly with this statute. He then shared they clearly coerced her. So just alone, the behavior in trying to control her expression is enough to violate. This is 100% a slam dunk, clear slam dunky here. He would later reiterate in his video. So he clearly believes it is indeed a slam dunk for Gina Carano. We also have analysis from New York lawyer Joe Niemann. He runs the Good Logic YouTube channel, and this is what he said after doing a similar video going over the lawsuit. He said, so 3 causes of action, 2 labor law, 1 sex discrimination. To me, first blush, the labor law one seems somewhat stronger. I don't know, but it seems stronger. I don't know enough to tell you how great it is. It seems stronger, but I like the fact that they went after it. So I do want to go over that Esquire does have a record of being successful when he gives his analysis. So we just need to go back to last month right here in January 31st when a judge dismissed Disney's federal lawsuit against the state of Florida, claiming that it lacks standing. If we skip down to here, we have Judge Alan Windsor says this. In short, Disney lacks standing to sue the governor or the secretary, and its claims against the CFTOD defendants fail on the merits because when a statute is facially constitutional, a plaintiff cannot bring a free speech challenge by claiming that the lawmakers who passed it acted with a constitutionally impermissible purpose. So basically, he's saying that Disney lacks standing, and that is exactly what Esquire said in a video last year on the WDW Pro channel discussing the lawsuit when it was initially filed by the Walt Disney Company. And this is what he said at the time, just to point this out. He said, for Disney, the nightmare scenario, the worst possible scenario, which is a likely scenario, I don't want to give exact possibilities, but it's something that could very much probabilistically happen, is the federal case gets entirely dismissed. It gets entirely thrown out. There's multiple reasons. The reason cited, one of the main reasons, which I have said from the beginning on this, which is Disney does not truly have standing. They do not meet the elements for standing. Standing means the ability to bring a claim to court. This is exactly the reason that the citizens who actually sued the state of Florida for these legislative changes way back earlier this year, they were thrown out for standing. Disney also can be thrown out for much similar grounds. So they're very likely to be tossed out, if not entirely, almost all of the accounts. So perhaps 4 of the counts might get tossed. You might have 1 remaining count there in federal court. So he obviously was saying that it was going to get thrown out because of standing. And indeed, that is exactly what happened. So he does have some precedent here on being accurate with his legal analysis. Obviously, we're talking about 2 totally different things here. Obviously, one being sex discrimination and some labor disputes. This other one being a zoning special district issue in the state of Florida. But we do have some legal experts weighing in and believing that not only does Gina Carano have a case, but she has a slam dunk case. So let me know what you guys make of this. What do you make of Carano's lawsuit against the Walt Disney Company? Do you think she has a slam dunk case, as Andrew Esquire says, or do you think that it's going to be a tougher row to hoe for her there? But let me know in the comments below. Remember to always be charitable, but to always speak the truth.